It is very easy to direct the program, and I'll be doing so with the help of the various colleagues. You will see them later. But just to be blunt, right? Sometimes it helps to just go for it. We're not taking a detour by having this event. We were not bored and felt that, oh my goodness, what do we do with our time? No, we're not. We're intentional about this. We will see it out. I just want to maybe talk much about the traditional leaders. I just had an interview now where the question was asked, to what extent is these events have an impact on society? And my response has been, any university or institution of higher learning, any law that leaves society behind has a problem. I don't know how to put it clear enough. You cannot run 100 kilometers per hour and society is just there. You've got to grow with the society. Professor, they talked about my expertise. I'm doing research in the intersection of digital technologies and law. And sometimes I get asked, why should we talk about the fourth industrial revolution when the majority of society is still grappling with some aspects of the fourth industrial revolution technologies? These are some of the questions that we should be asking. Are we growing and growing faster and leaving people on, behind? And our postures have to change, right? The way we do things has to change. We've got to change our mindset. We've got to change our attitudes. We've got to change our practices. I'm reminded, I'm not going to use the exact words. There was a CEO of African Bank who was accused of some wrongdoing. And then the journalist asked, "You've done all these things. What about the poor?" I said, "To hell with them. We cannot continue on that basis." This is a worthy exercise which should have been dealt with, in our view, a long time ago. We should have talked about this and found solutions some time ago. And hopefully today, which is the planting of the seed, I think it's Chief Mbuyiseli who says the sowing of the seed. I think it's, planting of the seed. We're planting the seed. We're not opening a talk show. When we talk about consolidating and modifying African customary law, that's what is going to be happening. We're going to modify, we're going to consolidate African customary law. We know the challenges in front of us. We will navigate those challenges. We know the road that we must travel, and we'll travel it. So I just want to plainly say that this panel discussion is not the first and last of the activity relating to consolidating African customary law. A team must be set up. We've developed a framework document. We consulted with related stakeholders to ensure that we at least touch on the topical priority issues affecting African customary law. And we hope that that framework document is going to deliver to us a solid consolidated project on this important aspect of the law. So mine is not a presentation, colleagues, but I thought I should say that are very clear, so that when we engage with the panel, we understand that this is not part of, oh, Forte has done it. Then what's going to happen? We have to action this, and we will. Colleagues, without wasting time, I'm going to ask the Vice Chancellor of the University, or the Principal and Vice Chancellor, apologies, VC, Principal and Vice Chancellor of the University of Fort Hare, Professor Buhlungu, to do a welcoming to this event. Thank you, VC.
Thank you very much, Professor Njotini, and good morning once again. I've never done it before, to welcome the same people twice, because I'm looking at all the tables. Basically, all the faces that were here earlier are still here, but once again, welcome. It's such a pleasure. We have to change gear. It's a different event. For me, it's a crucial event. It's an event whose time is now. What makes me proud about it is that this should develop into a big national debate, and at the end of the day, there should also be deliverables arising out of this. The idea that we had at the university and the invitation that we sent out to people was to say, let's come together and discuss the issue of African customary law. Where is it? What is its status vis-a-vis the other forms of law that we have, or form of law that we have in the country? Who are the practitioners? How is it transmitted? How is it transmitted from one generation to another? You know, all of those kinds of questions. Where is it, or how is it recorded? Is it recorded? Who should document it? And so on and so forth. And the practitioners as well. So all of those are questions that are in the mix. There's no formula. I had a sit down with two of my colleagues in the university to kick off this discussion and to request them that they should set this process in motion. And that was the Dean of the Faculty of Law, Professor Njotini, and Professor Ntlama Makanya, who was here earlier. I sat down with them. I said, listen, I don't have ideas. I don't have any views. This is the moment. After all, some of the leading lights in the legal system in the country were trained here, and some of the people who've written on African customary law studied here at one time or another in their lives, including Professor Koyana, D.B. Koyana, and so on and so forth. So we are the place. We are the place. Of course, as Fort Hare, we also gave birth to a few institutions. One of them next door, Walter Sulu. We don't want to forget that. They also produced great legal minds. Thanks to Fort Hare, if I may say so myself. Justice Madlanga, I'll retaliate now. For me, this is a thing. The format is set, and I'm hoping that it will not be the last moment for us to discuss this question. I see on the program, I don't understand why, but I will try my best and say something meaningful. But other than that, thank you very, very much, and thanks to the Faculty of Law at UFH for getting this done and for convening the people around us this morning. Thank you.
thank you very much, VC, and thank you to Ms. Malima. Perhaps I need to say this. I always say to my colleagues, the other deans from other faculties, and say, because they ask, why did you leave a particular university that wears, what's the color, orange? I say, one of the best decisions that I made was to join the Faculty of Law at the University of Fort Hare. Just when you think you know the faculty, you realize that there is more that you don't know. The colleague Lembongi Nibonayo Namhlanje is one of our colleagues, one of our administrators, dedicated administrators. He surprised us all. We are as surprised as you are about her talents. Thank you very much, Ms. Thelma Malima. Colleagues, I'm going to ask Chief Mbuyiseli to do the opening remarks. Thank you very much.
Masikhahlele kwindwalutho ezikhona apha. Program Director, Honorable VC, the judges that are with us today, the traditional leaders, the chief magistrates that are with us, the scholars, understand various academicians from other universities that are here, everybody, even the traditional communities. I greet you all, ladies and gentlemen. Firstly, let me, on behalf of the traditional communities, express my deepest gratitude to the university, this academic institution, for taking this bold step of paving a way towards the codification of customary law. This reminds me of the late Professor Koyana, the late Professor Mbuyiseli, who passed on lamenting about the codification of customary law in this country. Because there's no way, ladies and gentlemen, that in a country that happened to be colonized, we would find ourselves in a situation where we are dominated by foreign laws. It just can't be. It says a lot about us. We must actually begin to restore our dignity as people. It is therefore an honor to have each of you here today as we embark on a journey of exploration, dialogue, and understanding of one of the most intricate aspects of legal system. Customary law is not merely a set of rules and regulations. It is the heartbeat of our cultural heritage, reflecting the traditions, values, and norms that have shaped our society for generations. Its significance cannot be overstated, as it touches upon the very fabric of our identity and collective consciousness. Yet, despite its profound importance, customary law often exists in a realm of ambiguity, subject to interpretation and adaptation in the rapidly changing world. The question of codification, of formally documenting and systematizing these customary practices, stands at the intersection of tradition and modernity, preservation and progress. Today we gather not only to discuss the theoretical implications of codifying customary law, but also to engage in a practical exploration of its potential impact on the lives of the individuals and communities across South Africa. We recognize that this is not merely an academic exercise, but a crucial step towards ensuring access to justice, protecting cultural rights, and promoting social cohesion. Throughout our discussions, we will hear from a diverse range of voices: legal experts, community leaders, scholars, and practitioners, each offering valuable insights and perspective on this complex and multifaceted issue. Together, we will navigate the nuances of customary law, grappling with questions of authority, legitimacy, and delicate balance between tradition and human rights. As we embark on this journey, let us approach our deliberations with open minds, empathy, and commitment to understanding the diverse realities that shape the landscape of customary law in South Africa. May our discussions be marked by mutual respect, constructive dialogue, and a shared dedication to advancing justice and equality for all. I wish you all the best, that everything that goes well here in a manner that will bring back our dignity as people of South Africa. Thank you.
Thank you, Chief Mbuyiseli. Colleagues, I was looking around. I see most of the colleagues are young. I think the VC is young, Justice Madlanga, there is a singer by the name of Stevie Wonder. Yeah. One of his songs is titled Signed, Sealed, and Delivered. This is our way of saying to all of you that the Faculty of Law has signed, sealed, and delivered. So take advantage of this opportunity. I think Mbuyiseli did talk about it. We need to take advantage of this opportunity, have frank discussions, open discussions, honest discussions about the issues relating to the theme today. I'm not going to waste time. Justice Madlanga is ready. Apologies. Justice Madlanga is ready. He needs no introduction, colleagues. He's the judge of the Constitutional Court of South Africa. Advocate said he did indicate that he's a friend of the faculty. It's been it's something that has been going on for quite a while. We want to keep it that way. Justice Madlanga, do you mind coming to the front, please? Thank you, colleagues. I will then call upon to the stage the panel members. I'll start with the Principal and Vice Chancellor of the University of Fort Hare, Professor Buhlungu. Thank you. There's a story, also story that was told. Apparently the VC still needs more of it. Can I request JP Mbenenge to please join us, please? Thank you very much. JP Madondo. Thank you, JP. Chief Magistrate Ngubane. So sorry, JP. Chief Magistrate Mviko. Nkosi Dumalisile. I think colleagues have taken over the sitting arrangement, but it's fine. Nkosi Mduchane. Professor Nhlama Makhanya. Professor Moses Poko. Colleagues, thank you very much, Prof. Justice Madlanga will see out this process, how he wants to handle the discussion is, I almost said it's his business, but I'm looking for a clever term, an academic term. It's his responsibility. Yes, I got it. It's his responsibility. But the panel members will all be provided with a 2-minute, just a quick introduction about an aspect that Justice Madlanga will be talking, will indicate to every one of you. There will be roaming mics for the audience to ask questions, and Justice Madlanga is going to champion that. At this stage, I will leave everything to you, Justice Madlanga. I think, yeah.
Is it still good morning? Oh, yes, it is. Good morning again to the VC and all the guests present here, including the panelists. I will just have a very brief say. Acknowledging the status of customary law, the Constitutional Court said in the case of Alexco, while in the past, indigenous law was seen through the common law lens, it must now be seen as an integral part of our law. Like all law, it depends for its ultimate force and validity on the Constitution. Its validity must now be determined by reference not to common law, but to the Constitution. The constitutional imperative for the recognition and application of customary law is not accidental. I deal with this constitutional recognition shortly. We come from a past of parliamentary supremacy where, at the stroke of a pen and at whim, Parliament could and in fact did undo established rules of customary law. So terrible was the situation that customary law rules could be undone by individual so-called native commissioners using the test imposed by the infamous, open quote, repugnancy clause, close quote, introduced by Section 11(1) of the Black Administration Act. This clause was to the effect that customary law could not be applied if it was repugnant to, quote, the principles of public policy or natural justice, close quote. Needless to say, the public policy and natural justice against which customary law was tested for this repugnancy were those of the minority ruling race. Customary law is now law recognized by the Constitution. Subsections 2 and 3 of Section 39 of the Constitution provide, subsection 2, when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of this Bill of Rights. So we see customary law is mentioned specifically. Subsection 3, the Bill of Rights does not deny the existence of any other rights or freedoms that are recognized or conferred by common law, customary law, or legislation to the extent that they are consistent with the Bill of Rights, close quote. My contemporary Unkosi Apa may perhaps even question the very fact that in this itemization, customary law is not what appears first. I continue. Section 2113 of the Constitution enjoins courts to apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. Also, customary law is not at all subject to common law, let alone Western notions of public policy. Siske records the following. The process of colonization also involved epistemicide, that is, the killing of existing forms of knowledge, and the subsequent prevention of the development of that knowledge. Following Frantz Fanon, colonization had at its heart the effect of pushing black lives into the zone of non-being through a process of external and internal othering. External being material and internal being psychological. Part of the epistemicidal effects of colonization certainly related to the death of culture and language, but for purposes of the present discussion, it must be emphasized that a crucial effect was the discarding of African law and its replacement with a Dutch-inspired legal system. If no Cape-specific administrative legislation was passed on a specific issue, the laws of Holland, including the commentary thereon by the old Dutch writers, the Batavian Plakkaten and Roman law applied. It is this painful background in the recognition and application of customary law that the Constitution seeks to address. Let me stop here, for it is not for me today to expand on what needs to be said. It is for our esteemed panelists to do so. Now, I turn to them. My dear panelists, I would like each one of you, before I put questions to you, and before our audience puts questions to you, I would like each one of you to take not more than 3 minutes, please, just 3 minutes, to say whatever you wish to say by way of introduction. Thereafter, I will put questions to you. Let me start with the Vice Chancellor, and thereafter Chief Magistrate Ngubane, and then we come all the way, skip the VC, and then continue all the way to Chief next to me. Visi, please.
Something is not right here. No, the battery is flat. Sure. Thanks. The right Mosaba, yeah. Thank you very much, Justice Madlanga. I must first clarify that I'm not an expert on customary law. I did not study law, and therefore here I'm only filling up the numbers. But let me start. But there's a way in which I come in. Let me take you back, and I'm going to put in very simple terms, but to provoke a bigger discussion. I went to school, I went to high school in 1975, and the school was a special school. It was a school for the sons of chiefs and headmen. That's how it was, it's all. Angasikai. Also, I'm not a chief. I went there just because my aunt was married to Chief Mdicho. So let's not get there. It was at that school where I encountered General Mgwebi, who is from a traditional family, traditional leadership family, and Chief Mbuyiseli. But that's beside the point. The issue there was that the school was intended, and there were three of these schools. They were part of the apartheid project. There were three of the schools, Jongilizwe in Tsolo, Ibeguzulu in KwaZulu, and Ipinahare up in the north. I can't remember the town exactly. But the template was the same. They were to produce chiefs and headmen to lead the people. And one of the things that you graduated with at matric was a diploma in Bantu law and administration. And on the curriculum were two subjects that stood out. One was Bantu administration, the other one was Bantu law. Now, I'm raising this because that's where my interest in all of these matters came in. When I met with my professors here on campus, what was still resonating in me was that experience, because I sat through 5 years of being trained and being prepared. And indeed, many of my classmates before and after went on to become traditional leaders. So that's very important. And it was this training. But the only reference point that we had for training, for class, was a book, quite a thick volume, I don't know if it's still there, Bantu Law in South Africa. Bantu Law in South Africa. And that's where we learned about all of these customary practices and so on and so forth, whether it's to do with marriage, whether it's to do with, traditional leadership, polygamy and things like that. All of those things were contained in that textbook. Of course, they took it back when we left the school. Now, the issue that I'm raising here is then that from then onwards, for me, certainly, it was very clear that we're studying something, but this thing is not written anywhere. The minute I left school, of course, the minute I left school, there was no way, there was no reference point for me. You rely on collective memory in the communities. You rely on collective wisdom. You rely on experiences being passed from one generation to the next. And that word of mouth. There's nowhere that you can point and say, there is a law. Now, let me just fast track now, because the time is time to now. And we can all be very nostalgic about customary law. And that's the other pitfall. It's the other side. We can be dismissive or we can be nostalgic. Now, and we need to find a kind of a middle path here. The basis for customary law must be socio-economic. It's got to be founded on strong socio-economic foundations. Now, if you look at it now, customary law, the basis for it is very weak. The basis for it is very weak. The things that are supposed to support it are very weak. The institution of traditional leadership is weak. Let's face it, it's weak now. You know, you all have to drive down whichever way and see how people have basically been taking over land, and traditional leadership have no role whatsoever. Kunabantu bathengisa 5,000 iploti, and that's it. That's the end of the story. And if you don't have traditional leaders with authority, some of these things, and these traditional leaders are supposed to be the adjudicators in customary law matters, and they have no authority. Nobody respects them. Everybody bypasses them to go to the common law courts. Then you have a problem. And therefore, in confronting this issue, it's very important that nostalgia we put aside, that we don't romanticize something that's old out there. We find something that's going to be appropriate, applicable in the 21st century. And us as universities, therefore, it's particularly us, we must do the research. We must fall back not on nostalgia and so on. We must fall back on research and on science. I'll leave it there for now. Thank you very much.
Thank you very much, Program Director. Thank you very much, Justice of the Constitutional Court. We are so delighted that we have also been invited here as Chief Magistrates, talking in front of our seniors, our JPs and everybody, and also our seniors who are Amakosi Omtonya. So, and professors, we are so delighted for this invitation. I cannot expand more by actually introducing or acknowledging all people who are here, as it has already been said. But what is important and what I've learned as I came here are the words that have already been spoken by, for instance, Professor Njotini, who said any law that leaves society behind has a problem. If we look where we come from, we know that you are the people who actually took all the challenges that were here in Western Cape, Eastern Cape, when those people who came from abroad took over control of this land. And you resisted. Certain laws were imposed to you, colonial laws were actually imposed to you. Despite being subjected to that, you still continued practicing customary law until they realized that, you know, we cannot do anything about these people. We just have to abide and try to codify in one or another and try to see how we can actually help, you know, to get them to do what they want. Wait not for you. I don't think that it would have succeeded at other places. So we owe a lot of allegiance to you. We owe a lot of respect to you. Professor further said that Buhlezi, Principal and Vice Chancellor of the University, where is customary law? Where is it that states customary law? Who are the practicing or who are practicing it? How is it transmitted to our generations? Is it recorded? And there was also a saying by the previous singer who said, signed, sealed, and delivered. We are actually here to make sure that we enhance that saying, because it is very important if we can look at it thoroughly, we will not go wrong. Lastly, I would say I was intrigued, or I was so pleased by the fact that I'm coming to a university which has good values. You know, they say the values of Fort Hare University is to ensure that universal of justice, values of justice, integrity, discipline, life, kindness, non-injury, and concern for the well-being of others shall serve as a source of our thought, speech, and action. Signed, sealed, and dusted. Thank you.
Good morning. I'm Mbuyiseli Isaac Madondo from KwaZulu-Natal. When I heard about this discussion through Mbuyiseli, there are a number of things. Some say it's a codification, some say it's a consolidation and harmonization, the consolidation and modification. So I really don't know what it is now. But in any way, I'll request the chairperson, Justice Madlanga, to give me a time to make a presentation, because I have prepared something as a contribution. Even I did that under trying times. I didn't know whether I'm coming or not coming until 4:30 the day before yesterday. But despite that, I burned some midnight oils to get this thing done. Because this is a thing we have to do. If we don't do it, nobody will do it for ourselves. So when they talk about codification, what comes to my mind, that did a lot of damage to our customary law, because it did not give it an opportunity to grow and meet with the ever-changing circumstances. As it has been said, that it must go hand in hand with the socio-economic circumstances. It must miss those circumstances, because if it is behind all that, there'll be a big problem. So maybe I may not talk a lot, hoping that I'll get an opportunity if the chairperson pleases.
My dear audience, he did ask me, Deputy Judge President, and I asked him, how long is this? He said 5 pages. So I guess let us allow him to make the presentation, please. But for the rest of the panelists, please, not more than 3 minutes. Let's respect age as well, eh? You may go ahead, Deputy Mbuyiseli, please. Please. Oh, if you prefer standing there, fine. All right, good, all right.
I've greeted already. I need not repeat the greeting, because that will take much time. So, starting with the consolidation. To me, consolidation in this sense means reducing the plethora of disparate customs, norms, and practices to one, and make it stronger, to ensure uniformity, effectiveness, and common understanding in its application. That's my understanding. Custom norms and practices that are inconsistent with the Constitution must be modified in order to bring them in line with the Constitution. I think Justice Madlanga has also intimated that. Oh, okay. Customary law, well, we just talked about customary law. Some don't even know what it means. Customs, practices, and it means customs, practices, and usages observed among indigenous African peoples of South Africa. But some people, they just look down upon that. They don't even regard it. I'll use this one, Eastern Cape, because I read about Eastern Cape in that invitation. So one may not say why this man picks on Eastern Cape. Eastern Cape province boasts of disparate traditional customs, practices, and norms, and to prevent multiple legal systems operating in the area, such customs, practices, and norms need to be consolidated to one and harmonized with the common law, legislation, and constitutional values. Customary law, customs, practices, and norms are tied with ethnicity and tribalism, which in turn are rooted in chieftainships and kingships, which the colonizers and apartheid authorities used to enforce morality within the tribe and between the tribes. That was the position, which may make it difficult for some people to say, okay, let us give up our own because for the better results. Not in the negative sense, but I want to indicate the problems we may encounter. This may constitute a major obstacle to the intended consolidation and harmonization of customary law in the areas in question. Now, South African customary law is a body of law by which millions of South Africans regulate their lives in a multicultural society. Customary law, practices, and norms deal with standards and morality of the community. Such customary law, practices, and norms existed long before the adoption of the Constitution, which, among other things, aims at harmonizing the different cultural practices in the country. In 1994-1996, but it started in 1993 in the interim Constitution, customary law was recognized as being of equal status with common law. Both legal systems must be reconciled with the Constitution. But earlier on, common law was a big brother and customary law a little brother, or a stranded brother. So a difference is drawn between the indigenous law and customary law. So some people will be confused what I'm talking about now. Indigenous law are oral pre-colonial norms which the people observe in their ancient forms. Whereas customary law we have today is the adaptation of indigenous norms to social economic changes. That's what we must strive for. The notable example of this is the body of the Zulu law existing in KwaZulu-Natal, which is made up of two parts. The law, that is the Port of Zulu law existing, that was contained in the Code of Zulu law. There was a Code of Zulu law, and also there was Zulu Act on the Code of Zulu law. That one modified the ancient Zulu law in certain respects. And there's the one which remained unwritten and unchanged by statutory law. That one still exists. Is not done away with, but some people don't want to accept it for one or other reasons. Then we come to what we know as the living customary law, which I think that's the one we are aiming at by this discussion. When the influence and effect of the colonial and apartheid authority fell away from the behavior, conduct, and lives of the members of various traditional communities, the new set of customs, practices, and norms known as customary living law emerged to suit the needs of the society and enable them to adapt to the changing socio-economic circumstances. So as we know that under customary law, a woman is not allowed to participate in a negotiation of lobola for a daughter or receiving lobola. But now happens because some of the family heads that happen to be females, they have to be accepted that. Living law can loosely be defined as a set of rules, customs, and practices which the community in question does practice in the day-to-day relations with one another. Its meaning, living law is unwritten, non-state law representing the actual practices or customs of the indigenous community whose customary laws under consideration. In Alesco, at the Rachtersveld community, the Constitutional Court identified the unwritten living law, customary law, as a system throughout its history. Code has evolved and developed to meet the changing needs of the community. The court also observed that this system of law will continue to evolve within the context of its values and norms consistently with the Constitution. It did not change its norms because it's a law with its own principles, values, and norms. Its origin, maybe I've said something about it. The living customary law arises where the official customary law, that is the law found in statutes, case law, or textbook, no longer reflects the actual values and practices or customs of the African people. Let's say in the courts early on, they were just repeating and following that applying that law, only to find that things were changed. So that law does not have a meaning to the people who are adherents of the system. The development of customary living law is much informed by socio-economic changes in a particular society. Members of the community concerned apply this law to meet the changing needs of the community and to adapt to new situational realities of life. The living customary law derives its authority from its acceptance by the members of the community as a body of rules binding on themselves. The acceptance of social practice by a group is essential to the constitution of the practice or custom as a source of living law. The classical test for the existence of a custom as a source of law is found in Umbrella versus Jacobs, even though it's in the old case, but there's something relevant. Where the court held that for it to be recognized as law, a practice must be certain, uniformly observed for, it says there, for a long time, but now in our circumstances, it cannot for a long time, but it must show some uniformity and reasonable. It must be added that the past practice and tradition may be considered along with other important factors. In Shulubana versus Namitwa, the Constitutional Court endorsed the evolving nature of the living law as well as its to adapt to changing conditions in society. However, the practice of a particular community is relevant when determining the content of customary law norm. The content of customary law must be determined with reference to both history and the usage of the norm by the community concerned. The significant aspects of customary law for consolidation and harmonization. I have identified the following important aspects of customary law, which in my view need to be consolidated and harmonized with the constitution and constitutional values. But by saying that, I don't say the customer is inferior, but there are some other reliefs which can be obtained through the through the common law as well as through the customary law. So there must be equal brothers now. Transfer of land ownership. I think this one is a problem in all traditional communities. Under common law and statutory law, that's the Deeds Registry Act, ownership in land is only acquired through registration. Whereas under customary law, customs and practices, transfer of ownership in land occurs when the transferor points out a piece of land in question to the transferee in the presence of witnesses and states the extent of its boundaries. Such pointing out of the land to transferee by transferor being accompanied by the statement as to the extent of its boundaries in the presence of witnesses constitutes a valid transfer of land in our system. We don't need any registration. Such transfer of ownership in land that's arable or residential land descends from generation to generation of the transferee without interruption. Indigenous process, therefore, establishes an indefeasible and unassailable title in the land in question. Well, some people say, no, we don't know what happened. So, oh, no. As Amadondo, I inherited my great-grandfather's land. Everybody in the area respect that. However, the colonial and apartheid authorities did not recognize such form of transfer of land, and still in its say what? as long. Angazi, namaga angiqedeke lokho. Well, I'm told that it can be somehow long, but anyway, I've asked to finalize this one because I cannot leave it in the throat. However, the colonial and apartheid authorities did not recognize such form of transfer of land, and still it is not recognized by the government of the day. The customary ownership of land should be consolidated in all traditional communities and harmonized with common law and legislation relating to the registration of movable property. The customary ownership in land should be recognized by the relevant department by issuing a certificate of registration as proof of ownership on proof that the procedure stated earlier on has been duly followed. So, well, I'll make this available to your faculty because it's the contribution I'm making. Thank you.
Ngiyabonga Bhuti Mjabuliseni, enkosi kakhulu. I have whispered to the rest of the panelists that the remaining ones will no longer have the 3-minute intro. We are going straight to the questions. I have a request. I ask all panelists more than one question. I propose asking all the questions directed at a particular panelist at the same time. Each panelist must make a note of all questions put to them and respond to all at the same time. I will start with you, Vice Chancellor. The university has taken the lead or is championing the project on harmonizing or consolidating African customary law. And I'm being told by Professor Njotini that the university has taken the lead on this, and I believe him. Prof, what is it that the University of Fort Hare saw about the need for this project that others did not? That's the first question. Second, going through the framework document, I noticed that there is an emphasis on the fact that the project seeks to, open quote, harmonize, close quote, customary law. Please explain what the role players have in mind when they talk about harmonization. I'm thinking about the reality that at what I will call a micro level of adherence to and applicability of customary law, there isn't always homogeneity. By micro level, I have in mind what pertains kwabhaca, what pertains kugatyana, and what pertains engqushwa. Just to give an example, when you go to an area other than yours to be part of lobola negotiations, you will hear of concepts that you have never heard of or heard about before. Now, my question: how is it envisaged that harmonization will take place when sometimes there are these differences in the practiced customary law?
Thank you very much, Justice Madlanga. I'll be very brief. What is it that we saw that others did not see? Or what is it that we see that others don't see? Let me put it this way, I don't have all the answers to it. That's why I gave it to the Dean and Professor Ntlama, you see, so that they can do the thinking. But on a serious note, we as a university, unlike the majority of public universities in the country, are embedded in communities. We are surrounded by communities. We don't talk in hypothetical terms about communities. They right at the doorstep. We have to deal with issues every day. It's not common for a VC to have a delegation of very irate community members storm your office, the boardroom, and sit there and demand answers because their livestock have been impounded by the university. Things like that. It's because we sit with them. We work with them. We share many things with them. We share the river, with the water. Sometimes, the grazing is better on the Forte farm side than it is on the community side. So those things all have a bearing. The fact that these houses that are being built now all over, taking over, encroaching on grazing land, means that there's pressure on us because we have a huge farm. There's pressure on us. Those things, they make us think all the time. So for me, it's not a hypothetical question. It's a very practical day-to-day question. But secondly, let me also say that the student body that we have, the students are students from these communities. At least a good 60% of our students are students from rural areas, villages, from this context. So again, with that. And I can say the same about the staff. And so the other university that I work for doesn't have to grapple and confront with these issues on a daily basis. We do. We do in the nature of problems that we have to deal with regarding our students, our staff, as well as the community. So that's that. Maybe let me take it even further, that as a university, because of the way we're so embedded, we find ourselves having to intervene beyond the scope of what a university does. In about a month's time, we're going to be launching a water project, the Alice Water Treatment Works, because it's been re-upgraded by us as a university, not the water board, not the municipality, because they don't have money. We got the money, we rebuilt the water treatment works. So that's how embedded we are, if you want to understand. These are some of the things. So for us, it makes sense, therefore, that some of these issues and how they are adjudicated and how they are treated, it's an issue about us. It's not just nice to have. It's not just a research nice to have thing. It's a very practical issue at the same time. And of course, we'll emerge with younger people who are better embedded in the lives of their own communities by doing research on these things. And I'm hoping that with this also, this becomes the hub for researchers, young researchers, undergraduate teaching, postgraduate teaching and training, postdocs, all of this. This is part of the mix. We think about that. We also think about the publications that will come. But most importantly, we think about the partnerships that we have with the communities, with traditional authorities and so on. So I think that covers the first part. The question of the homogeneity, that's not there. It's very true. And I don't know. This is a difficult one. This is the difficult one. Back to my school days, we as young people then, young boys at boarding school at that time, we used to sit for hours and hours on end outside of class debating these questions because we were drawn from precisely these different areas. From these areas, so-and-so would say, in my area, in my village or my villages, we don't do it this way. We do it that way. And then some would say, the book, Bantu law in South Africa is wrong here. We don't do it this way. So that is part of the issue. It doesn't mean because there's this diversity and so on, therefore we pull back from the task. It means for precisely that reason, we have to. I'll give you one example. Perhaps it's not the best example. I often think about this because when we went to school, and this happens in other areas as well, where the subject is close. It's close. And there was one is close. Noba kokwenu uthetha isibhaca, noba uthetha isimpondo, noba uthetha isini, there was one subject. The harmonization was found there. It was found in practice by people writing. It was found in practice. And so in the area of customary law, I imagine that it wouldn't be such a big thing if we applied our minds to it. Thanks.
Thank you, VC. Judge President Benenge, with the judgment of Skippers J.A. in the Supreme Court of Appeal in the matter of Gongose versus Minister of Agriculture, Forestry and Fisheries, 2018 ZASCA in mind. So with that case in mind, do you wish to comment on the full import of what has been introduced by Section 2113 of the Constitution? That's the first question. Do you in any way take issue with the fact that the application of customary law by the courts is made to be subject to the Constitution and legislation specifically dealing with it?
Thank you, Program Director. Maybe for a contextualization of my answer, I need to start off by reading Section 211 within your hearing. It reads as follows. The institution, status, and role of traditional leadership, according to customary law, are recognized subject to the Constitution. I just wish to pause there and say, bear in mind the reference to subject to, which therefore means that there is one part of the clause that is dominant and the other one is subservient to the dominant one. So, all law must accord with the Constitution as it is the supreme law. Subsection 2 of Section 211 reads, a traditional authority that observes a system of customary law may function subject to any applicable legislation and customs. And then lastly, and more importantly, subsection 3 reads, the court must apply customary law when that law is applicable subject to the Constitution and any legislation that deals with customary law. Now, once again, you've got a subsection with a dominant feature and another one with a subservient feature, which means customary law applies subject, firstly, to the Constitution, and secondly, any legislation that deals with customary law. I'm getting closer to answering the question at hand. I wish to say the implications of Section 211, subsection 3, are firstly that all courts must apply and also recognize customary law. Number 2, the recognition and application of customary law are subject to the Constitution. Also, only legislation aimed at amending customary law is relevant. The courts determine when customary law is applicable. Therefore, courts of law must apply their discretion in deciding whether customary law is applicable in a particular case. Then the last attribute of the section is that should there be any problem in interpreting that particular provision, then one must resort to general principles of choice of law. Getting closer home, Gongose. The central issue in that case was whether the appellants could successfully raise the exercise of a customary right as a defense in criminal proceedings against them. They had been charged for fishing activities in an area that was regulated by the law that had since been passed. Whereas their defense was that we are fishing in this part of the sea in accordance with our customary rights, our rights of access to marine resources, and so their view was that they had committed no offense. And indeed, apart from what the Magistrates Court held and what the full court of the Eastern Cape Division found, the Supreme Court of Appeal was of the view that their conduct was lawful, in that it was in accordance with customary law. Now, the appellant had proved that at all times material to what they were doing, they had not committed any offense. They were exercising a customary right to fishing, and that right was not extinguished by legislation specifically dealing with customary law. So you can see here the interplay between, on the one hand, customary law, and on the other, the common law. Call it common law for present purposes. I know it's debatable. Fortunately, that is the position as enunciated in the Gongqose case. It is a case that has been followed in the most recent decision of the Eastern Cape in the Shell, you know the case, it's sustaining the Wild Coast and others versus Minister of Mineral Resources, 2022, a judgment of the Eastern Cape Division, South African Law Reports, page 589. So what have I been saying? If you look at it, to answer the question directly, it will always be of concern that customary law applies subject to the Constitution. But then the Constitution is an embodiment of the will of the people. It is actually us who willed, and the legislature then pronounced. But then, remember, the Constitution is supreme. So, the question now is, do I have a problem with that? I'm quite cognizant of the fact that there may be arguments. Why subject customary law to another body of law, both the Constitution and any other legislation dealing with a particular custom? The answer is, it is us. The answer lies or rests with us. We've got the Constitution. It renders all law subservient to it. Any law that doesn't accord well with the Constitution is invalid, isn't it? Yeah. So that's the long and short of it. I have got no qualms with the judgment in Gongqose. I do not have qualms necessarily with how the legislation is couched, insofar as it is based on a constitutional norm. Thank you.
Thank you, Judge President. Now, Deputy Judge President Madondo, you have written on customary law. To what extent do you think your writings have contributed towards what this project seeks to achieve? Why do you think the consolidation and harmonization of customary law are necessary? And who does this stand to benefit? Ungaphendula lapho bhuti, mnikeni mic, please.
Thank you. Firstly, I will say that that book is an exposition of what has been happening during the colonial and apartheid eras. And secondly, the problems we have as African people experiencing in the application of our law, because it was not regarded as law. It was only applied if it's not found to be repugnant or contrary to principles of natural justice. So all those things are brought to the fore in the book. And secondly, when look at the constitutional dispensation, how some of the issues have been addressed. Like we say, previously, the natural children of an unmarried woman could not succeed to a estate, simply because that was done on a table of succession prescribed by the male pre-Germanisha rule. So even if he was a male, it could take him some time until all the people in the group are exhausted. It's only then, but a female was not even considered. And further, a widow of a marriage in terms of customary law was not entitled to inherit from the estate of her husband. But all those things have been sorted out now through legislation and also through judicial precedent. And when we look at what the universities aimed achieving at the moment, that is the thing we need to do, because we have to revisit our customary laws, practices, and customs. As it has been indicated that there's a difference in the customs or practices applicable therein. So if that is remain the problems and modified to some extent, that it must be there must be some kind of uniformity, people will be happy, because if you go to another tribe, you may be not vulnerable to understand that you can be ripped off, because everybody will know a common rule applicable in that regard. So there are a number of things which have been attended to and discussed. Even in this case, J.P. Mbuyiseli referred to, is also discussed in the book, a number of others, a number of problems which we people we're experiencing, and we have to sort out, not leaving it in the hands of the politicians or whoever coming from anywhere. I don't remember the last one now. I think I have covered both. Yes.
Yes, you have, Buti. Thank you very, very much. Now I proceed to Chief Magistrate E.B. Ngubane and Chief Magistrate N.P. Mviko. Some would argue that most magistrates' courts are situated within the places where the living African norms and standards are predominantly practiced. I think this, in a sense, ties in with what the Vice Chancellor said. Some of these institutions are right where the customary law is applied and practiced. Can you explain the interface between magistrates' courts and traditional courts, and the place of traditional courts within the court hierarchy. What do you think needs to be done about traditional courts in this harmonization project? You'll decide who between the two of you answers which question. Or one of you may even answer both, and then the other one may add a little bit, just a little bit.
A difficult one. I already greeted, but I can just express the importance of traditional leaders. I can express the importance of restorative justice amongst the Africans. We are aware that that concept was taken and used by other people, and even some of our common law courts. But they are unable to use it in the proper manner in which our traditional court had started this concept. That's why it was difficult even to move away from it when they were requested by the colonizers to apply the common law. So the reason why I'm stating this is because it has relations with this harmonization. It has also relations with what is being done in the traditional courts and what is done in the magistrates' courts. Just to give you an example of how this is being misused sometimes. When I was still at the university, we happened to go to the courts, to visit the courts, to check how the courts are functioning. And on that day on which I visited that university, it changed my career to the West. Because when I went there to that court, which was adjacent to the university, I found a white child who was actually appearing before the court on the ordinary charge of theft of cheese and sweets of some kind. And then when the judge, or not the judge, when the magistrate, at that time, remember it was at that time when we had a magistrate, sometimes, I don't know whether I would say they were having all the qualifications. They had qualifications, but sometimes the police would not have qualifications. They would take the policeman to be a prosecutor. So, as a result, the magistrate said, what happened to this one? Why is he charged? Then they said, no, theft. Of what? Cheese. Why are you bringing this person here? Just take him to NICRO. And then NICRO had that restorative justice issues to deal with the children at that particular time. I don't want to tell you when. But then thereafter, I think two after that, came another African person, another African child, had also stolen cheese, chips, and cakes. So appeared before the magistrate. The magistrate said, how is he pleading? What do you plead? And the prosecutor said that, no, he's pleading guilty. Do you confirm that? Yes, I plead guilty, sir. Then just few talks and thereafter 3 months imprisonment. So can you see that restorative justice was used, but favoring certain types of people? So, but with us as Africans, it did not happen like that. That's why Judge Madondo in his book says, Restorative justice generally is a system aimed at preventing the negative effect of incarceration in respect of offenders who do not constitute a danger to society. Offending behavior is not seen as a crime against the state, but disturbance of equilibrium in society. It addresses the offending behavior by pursuing the offender to accept responsibility for his or her conduct, to tender an apology to the victim, to address the damage caused to the victim and society, and by reintegrating the offender into the society. The courts dispensing restorative justice are traditional courts, small claims courts and community courts. That was just bypassing. Coming to the, this book is available, is the one that he has been talking about. It says Constitutional Law in Constitutional Democracy in South Africa, has recently been published. About the hierarchy of the traditional courts and meshing it, or meshing the work, or meshing the traditional courts with the magistrates' courts. We know that, in fact, that was said by the Constitutional Court, that the magistrates' courts are there, you know, to dispense justice. And they are at the coalface of justice. If anything happens which is wrong there, obviously people will say there is no justice, because they see the magistrates' court which are not functioning properly, they are not serving people properly, so therefore people have that impression that there is no justice. So magistrates' courts are therefore forced to make sure that they cater for everything. In the previous act, that is the Black Administration Act, we all remember that the traditional courts had their own legislation and all that. Later, after they had consolidated the legislation in order to make themselves to understand what is contained in the, or what is done by the traditional court, they consolidated that, did everything, but did not work well. And then eventually, in the new democracy, the Black Administration Act was repealed except two sections, Section 12 and Section 20. Section 12 deals with civil matters that are dealt with by traditional courts. And then Section 20 deals with criminal matters that are actually dealt with by traditional courts. So that is still there. So the hierarchy that comes, that is there with the traditional leaders is that they have indunas, they have then inkosi, zomthonyama, and then they have izingonyama. So, but we are all aware that when it came to dealing with cases, Amakosi, in terms of that act, were supposed to bring all matters that they have dealt with to the magistrates' court to be recorded, and also for purposes of enforcement, Section 20 of the Black Administration Act, and also for the purpose of appeals. So it stood like that. But what was awkward is that the traditional courts, any person who was aggrieved by the judgment of the traditional court would not go to Ingonyama, but will have to jump the Ingonyama and go to Ingos. Go to the magistrate's court. So that was awkward. Why was it done? Is because they had an agenda at that particular. That's why it's important. When you think about traditional courts, operation of customary law, you have to know the history. You have to know where we come from. You have to know what happened previously that actually led to that action being taken by the colonizers. So, but that is important. So, at the current moment, can we thank the Chief Justice Mogoeng, because at his place, he noticed that the traditional leader was not operating in the manner in which he should be operating, to comply maybe one or another with the constitution, provisions of the constitution. He then spoke to, as he was in charge of the SAJE as well, he spoke to SAJE to say that, please, you are training judges, you are training magistrates, but traditional leaders are part of us. If they deal with cases, those cases come to us, and we have to ensure that cases are dealt with appropriately. So can you please have facilitators who are going to be going out to traditional leaders and work together with the traditional, because you cannot train them, but you are going to share information with them. They know better about about everything when it comes to these conciliation issues. So we embarked on that on the instruction of SAJE, and then it was in 2016 where we started training Amakosi. We went to various places, not training, but sharing information with them and highlighting certain things that might not be in accordance with the Constitution, which might actually clash with the Constitution. To that extent, we dealt with that, and then in the course of that, since we are sharing information, we said, we don't have any records of the cases that we are dealing with. Please, can you come tell us what you are dealing with in your court so that we can view it and check whether that actually tallies with the Constitution, whether it does not tally with the Constitution. And then we recorded that. We have pamphlets that they gave us. We would put them into groups, they would discuss and then come back with a uniform procedure that they want to follow, or the offenses, criminal, civil, all over, so that we can do what they want. And then that's how we actually dealt with those matters. And we also came here, the Eastern Cape, but Ms. Mvigo will just highlight a few about that part. We also came here, and we were so pleased about Amakosi coming from various areas where they gave us their offenses, and then we sifted some of them with their consent, and then they agreed, and then we had that. So lastly, I want to indicate to you that there has been a great improvement on the side of the courts. There has also been a great improvement on the side of the government now to make sure that traditional courts eradicate that previous act, the Black Administration Act, and come with a new act, which is Traditional Courts Act. It has been passed. It was not easy to pass it because people did not see in the way in which we are all looking at that. They said that, no, this act is going to empower Makosi to deal with wrong things. They are not going to recognize our women and all that. So it started in 2011, but it couldn't. In fact, 2008, it couldn't pass Parliament because of those challenges until it passed Parliament in 2021, and then in 2022 it was made an act of Parliament. So you can see, I don't want to praise Judge Madondo as well on that, because we had to sit down in the PEC and we said, but how can we leave everything to go like that? And if we see that there is a problem in the drafting that they have made, it will not be practical to apply it. Can we not sit down, do something that will be practical and submit it to Parliament so that they can, to the people who are drafting? And then they agreed. We submitted everything to those people who were actually drafting, and then we were called at Parliament to represent Judge Madondo, JP, DJP, actually presented that to Parliament. And from there was no stop. It went on to all the houses, and it passed until it became an act. And we are proud today that the courts are working very well. They will also be working perfectly, because what were the stumbling blocks in the Black Administration Act are no longer there. Coming to the issues of when a person does not want to come to court, in terms of the current act, has been called to the traditional court and does not come, then nothing would happen, to make sure that that person is forced to come to court. We just made an undertaking with the station commanders that they should help traditional leaders, whenever they bring letters that so and so did not comply, and then they would then go and advise that person to come to court, or take him on the day on which the traditional court is going to hold the court, so that that person can be addressed. But there is nothing. The previous act talks about messengers who must arrest, which you cannot do in the current dispensation. The arrest under those circumstances will be illegal. So all those things have been addressed in the new Traditional Courts Act. Enforcement has been addressed in the new, although the enforcement was there in the Black Administration Act, Section 20, and others, Criminal Procedure has been there, but it was not enforced in the courts because it needed the traditional court to register the judgment. If he has not done so, and then it would be so difficult even to appeal. Could not be appealing against the judge if it was not registered. So all those things have now been addressed properly. And even the sentences that can be imposed by traditional are very high, very high. So everything is quite in order, and we actually request, in order for us, it has not come into operation because they are still busy with the regulations, but in order for us to make sure that we make a meaningful contribution and working together with the traditional courts, we need that act to be passed. Thank you very much.
To the Program Director, Justice Madlanga, the Vice Chancellor, the JP of the Eastern Cape, JP Mbenenge, and our guests, and all the honorable, academics. I would say protocol observed. Inqanga nentsibazayo ngesiXhosa. Mine is very little. I am Nozuko Mviko, the Chief Magistrate of Umtata. The 99% rural. I have 5 kings in my region, and that is where customary law is practiced. It had fallen into disuse for some time. It was resuscitated after we started holding workshops with traditional leaders. To answer the question, Chairperson, mine is simple. 1, we are working hand in glove with traditional leaders. We have got a traditional court police in each and every traditional, in each and every kings, and also in courses in Nqila. I prefer to use la magama that are familiar. One of the other things that are important, we trained our administrative support staff. Why did we do that? Because we have Y2Ks. We call them Y2Ks. Those young children who grew up after 1994, they are appointed as clerks of the court. Those who used to be clerks of Nqila in the olden days, they have now retired. And those who are young, when Inkosi comes to the magistrate's court to have his case being put on the register for whatever reason, the young girl will tell you about the ICMS, Integrated Case Management System, that this is not listed. Those were the challenges that were there. And the poor clerk of Inkosi would then go back to Inqila with his records and end up those records the expiring, because there's time frame after there has been a judgment by Inkosi, which has to be enforced and recorded with the clerk of the court. So we decided that we must start from the grassroots and train the clerks of Inqila. Zonke, we call them Intumtata. We trained them. We also went around training traditional leaders. We're not training them. We work with them. We workshop with them, because they are the ones who train us, who are telling us about their customs and traditions. And we are the ones who are to sit down and say, what is it that is common amongst you? Hence, we are talking about consolidation. And in the Eastern Cape, we had a workshop in October 2019, where I was part and parcel of it, together with, I always forget to say, Chief Magistrate Ngubane, I call him Somahash, together with Ubabu Somahash. There were so many civil that we consolidated. We have a document to that effect. Civil matters like that emanate from adultery, like isiheula. People know about it. We have got ukukhetha. We have got, the criminal cases where a person grazing in a particular field, all those. And also the sentences that can be imposed, starting from the sub-headman up to the headman and traditional court. That is all codified. Should the university need it, then it will be available. But this is a SAJE document, because we're doing it with SAJE as coordinators. I don't want to waste your time, Chairperson. Thank you. The traditional leaders know about it.
Many thanks to Chief Magistrate Ngubane and Chief Magistrate Mviko. Many, many thanks to both of you. You made very practical presentations. Thank you. Now to my contemporary here, Nkosi Mbuyiseli. You will probably agree that the envisaged harmonization must start somewhere. In your view, what areas must be prioritized? In addition to the University of Fort Hare, who else do you think must take center stage in the harmonization process, and why? As a senior traditional leader, I assume that how traditional court structures operate must be something that is close to your heart. What would you like to see with regard to the nature of the jurisdiction exercised by these courts and the general manner of operation of these courts? Or are you happy with the statutory innovation that the two chief magistrates spoke about?
Thank you so much, Justice Madlanga. One tends to be rather confused because of the challenges that we face as traditional leaders. I would rather say, if only we could prioritize more on the law of succession, where problems are, as traditional leaders, trying to define our polygamous system as to how it works, and then begin to define those roles as to how they work. As far as I know, polygamy is irrelevant until there is no male issue in the Great House. There is no way that there could be a problem because you say you are all born by this king or a chief. All we know is this, that that Great House, ebiyabelwe, ibe ine male issues zayo, will have to take a lead to do things. Now we see a lot of cases, people coming up with a lot of disputes, so and so is not supposed to do this and so on. I think if it can be prioritized, we would really be pleased. Also, in the same vein, we could also talk of if the university or the institution could begin to clearly define who is supposed to be a chief, because there are a lot of claims these days. People, I'm supposed to be a chief, I'm supposed to be a chief. No. There is a way where, as far as I know, that if you could trace yourself according to the genealogy, that you can trace yourself as far as that particular king, then you begin to be in the royal house. Of course, before then, we know that we used to fight. Then if you begin, but now, this period in which we are, it has got to go along the path. I think whoever is the player, in which case I think the university has taken this initiative, they would actually assist us on that issue. Coming now to other issues, it says, the second question was actually, I mean, there's so many, if I may dwell more on the very first one, because we talk of the land rights. Everybody these days say, no, I own this land, I own this land. As far as we know, in our land tenure system, we still have land use rights in the rural communities. There's no land ownership right. But you'll find out that there is an unclear way of how the government is handling this, as well as our people. If also we could actually consider looking into that. African customary law often governs land tenure and governance principles, rather practices. Codification can impact land rights, land tenure systems, and governance structures within customary law communities, influencing land reform within customary law communities, influencing land reform efforts and socio-economic development initiatives. These things are very important that if we could actually look at them as one of the areas that we could actually prioritize as the university. Who could be players that could be added within what the university has actually started? We think community elders should play a role in this. Community elders, as indigenous communities, should actually come in and play a role. Traditional leaders, they've got to come and play a role. And also, I think South African Law Commission must also come into play to begin with all this. I think the last question was, the customary law starts with our families. There is a problem. Of course, we may perhaps know that it's a question of dysfunctioning of family systems. But everything starts with the family before it goes anywhere else. Then from there, if there's any conflict within that family, and then it goes up to the elders of a broader family. From the broader family, it goes to the spawn. From there, it goes to the chief. From there, it goes up. Perhaps. So if only we could actually begin to look into that and try to reinstitutionalize those levels of approach in things, I think it would actually help us. Maybe the university comes in handy there to actually even exercise, because we talk of this contemporary period where even the kids of today, they don't even understand what we're actually talking about. It's important that we bring them into understanding what is this all about. Thank you.
Diabulela Nkosi. Moving on to Unkosi Umdujan. Let us imagine a situation where the harmonization and consolidation have been finalized. What will this consolidation and harmonization mean to traditional leaders? How will it improve the lives of the people whom you serve?
Molweni nonke. I hope that you will understand my rural language of English and understand it the way you should be understanding it. I'm a rural person. I stay there every day. I speak Xhosa or Simpondo. So coming back to English now becomes a problem. But let me put it this way. I have a vision or a view that once this harmonization of the customary law, it will give traditional leaders many things. One of them is that it will bring back the dignity they deserve. It is unfortunate that we don't have that dignity, because everybody takes us very light. Even if you can say something, even the boys or the young people in your own area can say anything to you. So our dignity is being eroded. Some of the things that erodes the dignity of the traditional leaders is that they don't even understand themselves. Do you understand who you are? Do you understand the value that you have or are supposed to have towards the community, let alone the family that you come from? So those values and understanding will help the traditional leaders to be where they are. Secondly, the institution of traditional leadership, most of the time, the interpretation of themselves is the problem. We don't interpret the institution as traditional leaders. Sometimes we fight for the understanding of the institution itself. Who is an Inkosi? Who is not an Inkosi? Let me use these Xhosa words because the English ones have a problem. Do you have the history of saying how was Inkosi become an Inkosi before colonialism? Those are the questions that we should answer. And after colonialism, during apartheid, who was an Inkosi? The person is known as Inkosi. Who was that person? When I say the person, I don't mean myself. I mean the family. Ubukhosi bekubani kweyiphi indlu in this family. Unfortunately, in traditional leadership, all of us are from polygamy. I come from the Diko family, where Mduchane is the first son of Diko, which many people say are in Tabankulu, but Tina we are in Flagstaff, because Udiko came and assisted Ufako during the time he was fighting with his brother, and Udiko assisted him. Nezinye indawo ke, that will be there. But because we have got a tendency as traditional leaders to distort history, deliberately. We distort history. We don't even know that Udiko wayenabafazi abalithoba. We are still debating uphuma kweyiphi indlu wena and that one uphuma kweyiphi indlu. When it comes to Mduchane wayenabafazi abathandathu. All that, we are debating things that are not important to us. Now, if we cannot resolve our own, how can we resolve the community problems? Because remember that polygamy is not in the is even common families within that area. So that is the main problem that we should be, I think, is going to accept us. Thirdly, we have a problem of understanding the role that we should be, what should be playing as leaders. Are we there to look into ourselves? Are we there to politicize our own institution? As a result, we don't even know who we are. Because after 1994, fortunately for me, before 1994, I was working with the Department of Justice, then with the Office of the Premier, where in the Transkei, the traditional leaders were there. So I was a clerk there. Fortunately for me, most of the people didn't even know that I'm also a traditional leader. Because I said, if I can tell these people that who I am, I will not be able to resolve their problems, which I'm entrusted as a government employee. So those are the things, to me, which should be addressed. The last part in the first question is, traditional leaders are working in isolation. If I'm a traditional leader of purpose, where I am, those next door to me, like Espaqeni, Kwabala, have got nothing to do with me, which is a problem. You cannot work in isolation. We should be working as a team. Leading to the second question of saying, if we want to develop our own areas, we have to work as a team. And we don't have to say, because I happened to be in the leadership position of certain organizations, I cannot undertake or take one of the traditional leaders and say, because this one has got a vision to development, why can't I take him and put him and work together with him? For instance, all the land that are in the rural areas are lying fallow. And the reason, we are to be blamed also. Because the problems that we find ourselves in is not per se the lack of law, the lack of understanding by the people, but because the people are seeing us not only as leaders, they are seeing us as people who divides them. Because we recognize people who should not be in the leadership within ourselves and say, our Spanban is a chief. Whereas people know that this one is not a chief. His family has never been in that chieftainship, but we recognize them. Then in that case, I'm saying, if we want development in our areas, which is very painful, the families are divided. Utatu Madondo here put it that you find that the black child was taken to jail, but the white child was taken to the juvenile delinquency area. Now, we are still doing the same thing, because if I don't recognize you or have a problem with that family, I will say, let's punish them. But you can see that, this is not the case. You have to fight. For instance, in my area, I fight with the Department of Cocta. Why do you say I must fine people when in fact they don't have anything? You find somebody say, pay 1,000 rand. You know that that person, every day, they struggle to live. Then why do you say they must pay for doing something wrong? Instead of saying, call that family, educate them, that you are not staying on your own, you are part of this area. So therefore, don't do these things, because it's wrong. And then say, what is it that you need me to assist on in order to move forward as a family? There are a lot of kids who have never been to school. It's a pain to me at my age when I found that in my area there are kids who they cannot read and write. They cannot read and write. Then those kids, you'll find them stealing every day, small anyana things, and said, no, we're not going to take these guys or these kids to the police, because they will have a criminal record that will be there for life. Why can't we talk to them? So development comes from the attitude on which we as traditional leaders, we should be leading on. Now, that's number one. Number two, you cannot develop people who are uneducated. Training an uneducated person is difficult. I'm a training officer myself. I started training. But when you go to somebody who doesn't have a school, don't even have to read and write, no, it's not easy. In politics, we used to say, we used to say when we were doing politics at UNITRA, school education helps you to think positive about yourself. Now, if somebody has not gone to school, what thinking are you thinking that person is going to think? Negative things. Every time you say something, it's negative. That is why people are saying today, 350 is a step forward. Amen. But I'm sorry, I'm not there. So lastly, I'm saying, once we work together as traditional leaders, we understand our communities, then this customary law thing is going to assist us develop those areas rather than being neglected, because currently we are neglected. Not even a person will say, what development? People are crying about water, but I'm saying there's no master plan for rural areas. Nowhere. You can't find it. Those who have got water is by chance, but there is nothing. So I'm saying, in view of that, we need to sit down and then look at how our resources can be used together. Thank you.
Diabulela Nkosi. Professor N. Makanya. Part of the criticism of the nature of customary law that has always been applied is that it was frozen in the writings of white academics and court decisions by white judicial officers. it did not keep abreast of developments in the customary law actually practiced on the ground. If we harmonize, consolidate, codify customary law, do we not run the risk, and I emphasize codify here, do we not run the risk of yet again freezing customary law at a particular point in time? How must we make sure that what has been consolidated, harmonized, and codified, which I assume will be in some document or documents, will keep abreast of developments? Of what practical significance will the consolidation, etc., be in the transformation of society?
Thank you, Justice Madlanga. You know, the question that we are pondering today is traced back in 1956, whether customary law can be codified or should be codified. It was in 1956. And there's progress from then. And Bennett raised this question in 1980, whether customary law can or should be codified. With the history of looking customary law through the lens of the interpretation by old white men without a background of the context in which a particular community practices or exercises its customs, that tended to dilute the way in which those practices should have evolved. I am not going to go through that history because my interest today is on constitutionalized customary law, post-1994. And what made me to be so interested at the early stages of the democracy, Justice Sachs in Makwanyana, nobody had an experience on how to steer the democratic ship. But Sachs said, it is very concerning that legal textbooks, the jurisprudence that is coming from the courts, is not drawn from the experiences of the people that are living the particular law. That's what Sachs said. And he had a transformative vision that the courts now are put in a pedestal to apply customary law from its own context. If we do apply customary law in our own context, this purpose of envisioning a uniformed application, it is envisioned. We are all aware that we do not have a national system Justice Madlanga said so. We do not have a national system of customary law, but customary law share common practices. Then we differ on how we exercise those particular practices. If you look at Lobola, the Xhosas, the Zulus, the Tsonas, they all Lobola. And the uniformity was brought by the Recognition of Customary Marriages Act was for the custom to be exercised and enjoyed as per that community. So I'm seeing the intersection of the living and the official version of customary law, that we are allowed, that 31B integrates the harmony with the living version. An issue was made of the role of the traditional court system as an institution sitting here today. We are not just want to excel, we want to influence policy. Look at the judicial structure. You unearth traditional courts from other. Section 166 of the Constitution, it is where you draw any other court established by legislation. If today I have to stand here and justify who I am,
May I request the professor to please zoom in on the freezing, the codification and the freezing, please.
Okay. So the codification will enable us to influence policies, as I've said. Because as we stand, we do not have an identity. Because we are other. If the foundational values in section 1, they are founded on equality, supremacy, the rule of law, having an equal status in a customary law system, then there's a negative implication on the impact of those foundational values on the identity of the system itself, because we are other. So in keeping abreast with the developments, the interrelationship that has to exist with all the stakeholders, Unkosim Dujane said here, the house is divided itself. We are here to influence the way in which they view the living together as treasurers of African heritage. I was with them in Bishop for a whole week. We were fighting about people in same-sex relationships. They don't even want them in their traditional courts. I was asking the very same question. Are you not the treasurer of collectivism? Are you not the treasurer of preserving the identity of each one? So this day is meant to influence the change of attitudes Not only for the institution, but for all of us as well. Because it's not only us who discriminate against people in same-sex relationships. Because Tanzania and Uganda, they even went to an extent of passing laws to deal with people in same-sex relationships, whilst we treasure the value of Ubuntu. That is us. So to make this day practical, is to identify those gaps so that we address them. And through our own academic writings, my own black reviewers, when I was explaining what is inkomo yesondlo mean, inkomo yesondlo, Kambeg says, this is not what I have read. I'm telling you. I had to explain what is inkomo yesondlo. This is not what I have read. So this day is to influence the way in which, in a constitutionalized system, how does customary law find its own space to influence the Constitution itself? It must be the lens of the Constitution that has to be influenced with the way in which issues in customary law are addressed. Justice Madlanga, please excuse me. You know, they are very high-heeled. When I say no woman to the throne, no woman to the throne, you can hold all any other positions within, but not the throne. I am opposed to why? Because of gender equality. Because the institution has to transform. Yes, it has to transform. But is the transformation under the concept of gender equality linked to a legitimate purpose of preserving the identity of the institution? This is not about the royal family. It is about the institution of traditional leadership. So we are here to influence the way in which we interpret the Constitution in the context of customary law. Chief Mbuyiseli made mention that you struggle about succession. Yes, you do struggle. Why? Because there is a confusion or misinterpretation of succession and inheritance. Those are the things that we need to debate and address them. This is the purpose of today. Because succession, you succeed to the status of the person who was holding the position. But inheritance relates to the family property. Then the royal family, you can decide, as okay, who gets the Mercedes-Benz, who gets the house and so forth. That is for your own. That is your inheritance. But give us our status. Give us our status. So in a nutshell, it is my interest to see this day putting measures in place that will ensure that customary law Dr. Madondo is not just a poor cousin of common law. But if customary law is given an equal status in regulating the authority that is exercised by the institution, and let it be allowed. Let it be given that space. So that we don't stand in this podium and start talking about traditional leaders that are illiterate. Because we are here to influence, to inform, so that our own system does not remain an other. Justice Madlanga. Yes, I'm done. You have to do. I'm wearing the other cap. I'm wearing the other cap. In my other cap, when a witness has to come and give evidence, he has to swear to God. Raise your hand.
Right hand.
Yes. Raise your right hand and swear that you are going to speak the truth and only the truth. But those are the things. In fact, there's so much to talk about this day. It's just that we don't have time. But I hope, Prof. and your team, you will consolidate today's thoughts. You have a framework document that will drive this process. Not just the framework, but the framework that will ensure that there are practical steps that will be taken from today in ensuring that this envisioned program does not remain here. I'm saying this because I'm also staying in the village. So I don't know, I know very well what it means to be a villager. I know what it means. Thank you very much.
What passion. Thank you very, very much, Prof. And we move to another academic, Professor Poko. The role of traditional leadership is recognized in Section 211 of the Constitution. Do you think this recognition and the way it is enunciated in the Constitution is enough? So the question is different to the one I posed to the Judge President. So is the way in which it is enunciated in the Constitution enough? I think in a sense, Professor Nhlama Makhanya did raise the issues that in a sense bear relevance to the question I'm putting to you. Second question, or do you think more needs to be provided for in this regard? In fact, this is as good as one question.
Justice, Chairperson Madlanga, and fellow panelists, good afternoon. Good afternoon, ladies and gentlemen. There are two advantages of being the youngest in the panel. But I will start with the advantage is that you present when you have heard the wisdom of all the speakers. The disadvantage is that you present when everyone is hungry. So, Chairperson, I'm also hungry. Therefore, I will try to be brief in my response. Let me first start by conceding that it is unfortunate that as we approach 30 years of democracy, we are still discussing but not implementing. It is really unfortunate that over the 30 years period, institutions of higher learning have produced thousands of graduates, including the ones dealing with aspects with more or less the same issue in KwaZulu-Natal. But I think that the Constitution is not going to solve all our challenges, especially those of the traditional leadership. The question is how they should be rather capacitated in order to ensure that they effectively play their roles and give effect to the constitutional mandate. Capacitation comes into many ways. It's for the lack of better words, in some instances, you take someone, then you throw them into the position that these are the playing rules upon which you are supposed to play. But when you talk to them and issues that are related to the Constitution or the law, they have no idea how to apply them. So that's where the challenge is. I don't know, perhaps we could enhance the education, support structures, and so on. But the answers will not come today, all of them. I'm reminded of a former colleague who once said, the duty of academics is not to answer questions, but to raise questions and research on them. Chairperson, ladies and gentlemen, let me not be fooled. I thank you.
After being unruly and insisting on your 3 minutes, you were brief once you came to responding to the question, and you did so wonderfully. Thank you, Prof. Now, to our audience, I invite questions from you, but because we've been at it for quite a while now, I will perhaps evoke your anger, because you want to say something, Prof? No. Or because I will ask for only 4 questions from the floor, please. And please indicate who you are directing your question to. Not me. Not me, only the panelists are fair game, not me. Thank you very much. And perhaps for the record, if you don't mind, I've done something to this. Can somebody please help me? Please just make this firm again, please. For the record, please state your name, Sisi. And then put your question indicating who it's directed to.
Thank you, Judge. In fact, it's not a question, it's a homework. And I'm very happy. Oh, do you know Kamdendi? Kutamako Institute. Unfortunately, I'm living in 2 worlds, the rural and the urban. But the Kulelegu rural, so you'll forgive me. I'm very happy today that I'm talking to judges and magistrates, because and one thing I will never do, can't say court, is, as Professor Tlame said, for ijudge kwayimanje athi mandiphawu isandla sase-right xa ndifunga. Ufunga is not from outside, it's from inside. Mna jaji uba uthi mandifunge ndiyakuxela uba ndiyacamagusha kumazisi, ndiyacamagusha nakuqamata uba ndizayithetha inyani. So if ufuna ndifunge nyani, allow myself ndifunge my own way, not the way ofuna ndifunge ngayo. The comment, it's a question and a comment. The question, I'm always worried, Yeyoba, which approach are you using in having this recognition of this customary law? Because to me, I may be wrong, it seems as if it's a big brother approach. Because it's based on a law, a foreign law that came to my house and I accepted it, and now it is saying, I want to recognize you. You can't do that in my own house. It should be the owner who recognizes the visitor. So which approach? Now, which areas are you going to
Do you mind indicating who you are directing that to? We have magistrates.
Okay.
We have a deputy judge president. We have a law professor. We have another chief magistrate. We have a judge president.
Okay.
Another law professor here. Who are you directing your
That's easy to judge President Benenge. The problem, with my other head, I'm working with the committee that deals with traditional leadership disputes and claims. And they were told you must deal, you must follow the traditions of that particular group. But now, the question of ukungena, we will be told ukuthi lo mntwana lo lenkosi sifuna ingene apha wabhubha it's 7 years back waze ke ngoku wangeno. Oh hayi ke ithi tradition yabantu ungeniwe ngumntana lapha lo. And then I go to ijudge izandixela uba you were born posthumously 7 years. No. I call on to le asiyivumi. So it zithini ezi laws zimbini, which one dictate to each other? And uzala ngedolo. That is why
I will intervene and say, if you don't mind, let's pose that one to Professor Ntlama.
Ukungena ukuzala ngedolo, because xa uye nami engenamntana.
And I hope that's the last one.
That's the last one. Ukuzala ngedolo. Xa umye nami engenamntana, ndingayothatha phaya umntana ndimzale ngedolo abe ngowam. Because judge, I'm the minority here. Allow me one question now.
No, please.
The marriage officer,
no.
judge.
Because now I said 4 questions. Now one person is asking many. Please, Sisinda.
But you are being imposed with the onozakuzaku. The judges impose onozakuzaku to us, but they don't do it from one who has married the Christian way. Why that segregation? Thank you.
Thank you, Sisi. The second person, please. Where are the roving mics? Oh gosh. Yes. That's 2 I've heard. Let me mix it. The gentleman over there. Something lime or something. I'm trying to prove that men do know colors. That gentleman over there. So that's 3. And then the last one. Let's have women in the majority. Okay. She defers to you because I was looking at both of you. She defers to you. Yes. Where do we start? Yes, please. And sorry? Upi.
That is why I'm standing.
Oh, I can't withdraw the people that have already. So that means you will be the 5th person, or one of them will be the 5th person. Please, Chawe, thank you.
So number 2 is one of the numbers.
Sorry.
So I'm number 2 now.
Yeah, please ask your question.
Okay.
But now, please, only one question.
No, there's no question.
Oh, okay,
Yeah,
fine,
I'm
thank
just,
you.
rescuing you. Thank you very much. Actually, let me thank you, Somklad, for this program. You have done a good job, which means you've got brains. You know what do you want, because you're the academics. Number 2, this seminar, it is a waking up call. Oh, before I go further, go Sukyali, go Tsendandi,
Diabulela.
egodidi ndisuka apha etyhume pheshe kwenciba asihlanga ngothanda uhlala umlambo kwafika uhlanga lomhlophe kwazalwa thina sizalwa ngapha otomkhulu bebona bezalwe ngapha phamba sizalwe bebekhona abantu phamba lufika uhlanga lomhlophe bebekhona abantu bekulawulwa kwelizwe kha kubuzwe into umntwini ngoku siyabuzwa ba intoni umsebenzi wenkosi siyawazi thina. Number 3, ayizosinceda le nto siyithethayo de kuthiwe istipend masiphume komkhulu. Mandiyiphinde, masiphume istipend komkhulu. Sesinje sixatazela kulaa mali sifunjathiswe yona. Number 4, siyayicela le program iye kumakomkhulu kuyothethwa nathi ba silahle phi. Ngoku simi kuMzantsi Afrika xa sikhumsha sithi we are in a democratic South Africa. This is South African Republic. Go to the dictionary and find the word. We need Republic of South Africa. Now we're talking about liberation. We don't need liberation. We need emancipation. We're missing the point. Then we'll be able to move forward. That is why for the problem in our families, if I'm rich and intelligent, I'll be the prominent person even if I'm the last person to be born. The first one has got no money. The first one is not educated. So if I'm raising the hand in a meeting situation, we're not playing here. We are addressing issues here. Because I've got no money, I've got no status. Then the person who's able to say something is the one who's rich and moneyed. So let's go back. The first point of departure, let's take the payroll from Amakos.
Thank you. Diabulela Nkosi.
Protocol observed. Igama lam ndinguNoluthando Mbangeleli. I'm within stand. Oh, igama lam ndinguNoluthando Mbangeleli. I'm with the University Faculty of Management and Commerce. So with this initiative, we are definitely driving towards inclusivity. We are driving to harmony. We are driving to modification. Omncinci ufuna ufunda komdala, omdala ufuneke afunde komncinci, you know. So also to start to the dean, to future for these such occasions, I would love to see more young in the panel. I would also love to see more female in the panel. Now my question to Chief Mbuyiseli, if I'm pronouncing it. Yes, apology. Is that what mechanisms, you know, what strategies can we use to come to this inclusivity that we are looking forward to? Because you did touch base on some of the stakeholders, you know, and most probably stakeholder ngasinye sitsalela ecaleni layo, but that also needs to end, you know, the isolation that was mentioned also by your colleague next to you. So what strategies and what mechanisms? Thanks.
Thank you.
Thank you very much, Program Director. All protocol observed. My name is Lepongo Simtemle Khalan. Firstly, I'd like to say, as an aspirant young scholar, programs like these are very welcoming and give us hope that one day we can be in your positions as scholars and contribute to the wide body of literature that is already there. And also to acknowledge Justice Madlanga, who has always been in the case that I've read as a law student at the University of Fort Hare. But mostly my question is directed to Prof. Ndlama, the co-author of the book that we are here today about. And it reads as follows: considering the potential of African customary law for community-based accountability, restorative justice, and respect for elders and leaders, how can anti-corruption strategies aimed at regulating the rule of modern South African traditional kingdoms contribute to creating a sense of accountability within these systems, ultimately serving as a foundation of social justice? Which Ingosi utate bephakamile wathi, so that kungaxhatshazelwa kula mali, then coordination starts from there. Thank you.
Sorry, two things. Who did you say you're directing your question to?
Prof. Ndlama.
Prof. Ndlama, just a minute. Then just one very small but important matter I did not study at Fort Hare. The several references to me being a friend of the university is alluding to the fact that I come here all the time. I was even a visiting professor at one stage, and I have come here for various other reasons. Thank you. I think we have someone else. Oh, yes, thank you.
I would like to extend my greetings to everyone in the house, and exceptionally warm greetings to our panelists. My name is Gina Makoka, and I want to ask a question. This question is not directed at anyone specifically, but to all the panelists that are currently there. My question, in fact, I had two questions, but I tried to confine them into one question. So, my question, I will
Please don't ask the question and then say "and," because it will still be two questions. Please just ask one.
Okay.
One, please.
I'll be sure to take that into consideration. Now, in my question, I will make reference to the case of Shilubana versus Nwamito, which legitimized the inheritance of chieftainship by female heirs. And in the context of this case, it meant that the chieftainship would be transferred from the Nwamito household to the Shilubana household. Now, where the Honorable Justice even stated that, accordingly, the choice of Miss Shilubana as Hosi should not be viewed as a development of the customary law, as customary law is necessarily flexible. Now, I want us to urge us not to ignore history, cultures as a nation, the very essence of what the institution of traditional leadership should be dealing with. Now, do we have to favor the constitution at the expense of our customs, and specifically the inheritance of chieftainship by male heirs? Isn't that, and I quote, distorting history and thus rigidly imposing changes on the realm of the living customary law, causing radical changes that follow from the extent to which the courts are dragging their feet when it comes to developing customary law? Because now, as Prof. Ndlama stated, and even on several occasions, Advocate Tembeka Ncukaitobi, our customary law has become the ugly stepsister of common law. Thank you very much.
Thank you very, very much. I think, yes, the last question here, please.
Thank you, Chair. Thank you, Justice Madlanga, and the House at large. Before I can make my comment and a small question, I would love to take this opportunity and thank my lecturers. I'm a product of 14. I'm a legal practitioner. Ndiphekwe apha ko Prof. Ndlama. Sebenze no VC or Advocate Seti were my lecturers. I take this opportunity to thank you, all of you, for making me who I am, because this is the right opportunity that I'm having right now. bekukho amagingxigingxi whilst I was a child. I was a child when I was here. But thank you for your perseverance, and thank you for ungazikade imisindo yenu to be who I am today. Ndithetha kwinhlangano yenu. May God continue to hurt you by his love and his grace. Coming to the purpose of my standing, I'm carrying a mandate from Inkosi Zamagcaleka, where Unkosi Umgwebi is an SG. A mandate endiyiphathisweyo phantsi ezankosi as umuntu osebenza nabo. A way forward and a question, just a small question. As speakers have already alluded about the constitution of our country, which is a loose document as far as our norms and customs are concerned, because I've got a strong belief that customs, they vary from culture to culture, from constitution to, from society to society. The question, why the Roman Dutch law that seems to supersede our culture? If I may quote the Bear case, the Winnie Madikizela case, the King Mbuyiseli case, if we had by that time of these cases, our customary law courts, the decisions that were made in these cases that I've already mentioned would have been made differently, because these cases, their nature, they belong to the customary law courts. But now the Constitution yenze intando yazo yayo ngezi cases, because that Constitution is not meant for our democracy, as the word is beautiful, to entice a person who doesn't know who or he or she is. So if as a case is ya bezisiwe kwezankundla, ngesingekho kule ndawo sikuyo ngoku, ngesingazange sabanayo inkosi iking yethu eyabanjwayo, ngesingazange sabanaye uWinnie Madikizela ongazange afumane i-estate yakhe as the wife of uMandela ifunyanwe ngumuntu o-1010, ngesingazange sabanayo i-Bear case into ye-primogeniture. Customarily indlalifa yeyendoda. Into zendlalifa zenza amakhaya ethu angakwazi ulawuleka, because i-patriarch, it will always be a man. Now xa ndizawuhlala phantsi, the mandate endiyiphathiswe ziinkosi zamagcaleka, way forward 80, number one, this is not the first time we are crying for the consolidation or the modifying of this customary law. But this time we'll make it a point that it does not end here. And this time we'll make it a point that we converge with our traditional leaders of various societies to make our dream a reality. The way forward, number one, we are here to urge you or to urge all the stakeholders that this constitution needs to be amended. That is the first step. We cannot do anything. We cannot open any customary law court before we amend this constitution. As J.P. Mbenenge alluded earlier before, that the constitution is the supreme law of the country, and therefore any law that does not accord with the constitution
Can
will
you
remain
please try to
invalid.
Summarize?
When I'm summarizing, sorry, Justice Madlanga, to summarize this, we must amend the constitution. Number two, we must educate our traditional leaders, and they must not take a back seat because this thing is theirs. The sections that are of crucial importance.
Just do it in point form, please. If you have 4 points, just mention the 4 points without
Okay.
substantiating on each one of them.
Okay, it's
Thank
section
you.
39, subsection 2. It doesn't say anything about our customary law, our customs of the Constitution. Section 11 of our Constitution speaks about the right to life. They knew that izibhoja nabantu abanentshisakalo yokulwa iza kuba sithi. Therefore, obuleleyo makakhutshwe kodwa ubulele for uba makahambe obulala omnye umntu. It doesn't serve any purpose, la section ka everyone has the right to live. And then coming to issue ye salaries zenkosi, yonke ngokulento i-commercializiwe so that ezinkosi ziluze i-focus, zigxile emalini. Kuthi xa kufika i-community projects zifailishe because members of the society and the amakhosi alo particular community were not involved. Ufumanisa uba ii-projects ziyathini ziyafailisha because iinkosi ezikhoyo ezingenambono ngoku ziyafunjathiswa ngee-projects zethu. Kuphethe ii-royalties of our communities zisiya apho singaziyo. Ubona i-project ingakhange igqitywe but bonke abantu abaxhamleyo behamba ngee-Range Rovers. We are urging this meeting that it must be at least a reality because ngoku ixesha limkile siyonzakala ilizwe lethu selimkile already xa nihlala phansi justice. Noko zinkosi noba sowubrayijiwe ngantoni awunodi ukhupha inxiwa ulinike iPakistan. Our communities, our land is captured by Pakistanians all over. When iPakistan lithatha umhlaba ezilalini, yintente bazabanzima umasipala angaliniki isite phaya. And therefore ngokuthina sizawuthi miste sikhutshwa emihlabeni yethu ngabantu bokundwendwela. And the last thing, Justice and the House, is that if the team ilapho zonke ezi stakeholders can see to it that as much as they have a right to be here, I'm talking about the foreigners, I'm sorry to say that we must see to it that i-permit yakho uba wawuze nge-asylum mayibe yiyo. Uba wawuzofunda ugqibile ufunda hamba phindela kwalako wenu ilizwe. Uba ngaba i-permit yakho i-expirishile awuzukwazi uhlala apha because ngoku sine-problem kwilizwe lethu. We want to put our house into order. Thank you very much.
Thank you, thank you, thank you. Oh, sorry, did you mention your name? I've forgotten now.
Okay, my name is Nosipho Mthuzula. I'm working for Lutango Stawo Atenis.
Thank you.
Ifem yasebukum kanini kingdom yamaXhosa.
Thank you, thank you. Judge President, please.
Thank you very much. Ndizawuqupha ke Camagu, Dr. Mdende. The disquiet you have expressed seems to point a finger at section 211, subsection 3, which says the court must apply customary law when that law is applicable, subject to the Constitution and any other law that deals with customary law. Here lies my answer. It's either I am correct or I am wrong when I say the Constitution is an embodiment of the will of the people. It's either I'm wrong or I'm not wrong. And therefore, it seems to me that the question posed, it's a very direct question, which I think Ms. Mthuzula has endeavored to answer, which Professor Ntlama endeavored to answer. But I'm just going to say, it is not possible to repeal section 211 insofar as it echoes that clause in the Constitution which says the Constitution is the supreme law. All law that is not consistent with it is invalid. And therefore, another possible answer is...
You needed 2/3 majority to change it. Yeah.
I was just about to say that.
Sorry.
That's the point I wanted to make, which is that if there is a problem, the question to be posed and answered is whether the time has therefore not come for us to say that section must be amended. we know the story. We know what procedures should be adopted. But finally, the answer proffered by Professor Ntlama seems to be suggesting that if there is not going to be an amendment, then it means customary law must influence the rest of the constitutional provisions. And ilapha kuthi ke loo nto uba siyiphumeze okanye singayiphumezi. And I thought that was a question that was posed to me. Thank you.
Thank you very much. Chief Mbuyiseli.
Mrs. Notando, I think your question was saying what mechanisms can we use to harmonize this program? Hello, can you hear me? That's right. I think, Mrs. Notando, you were saying, your question was what mechanisms can we use in order to harmonize this program? I think this is well suited when it is with the university. I would foresee a situation with the kind of complexities of challenges we have. Maybe it could go further to inviting some other disciplines that could actually address the situation the challenges that we're actually faced with. I cannot go any further than that because when it is seated here, it is seated with the kind of people who are here. In essence, they are here to research. In essence, they are here, as intellectuals. They could actually know, with the kind of challenge that is out there that is facing our society, what it is that we can actually do. Thank you.
Thank you. Professor Ntlama. Ntlama Makhanya.
Okay, thank you very much, Justice Madam. Professor Mdende, your question was directed on particular customs. Yes, hello? Your question was directed to particular customs. And I must state that since 1910, we have 5 constitutions. But the one constitution I will focus on is the 1996 one. Because that constitution, if you look at the commitment, that seeks to oversee the different legal systems that are applicable in the Republic. Because that commitment seeks to acknowledge South Africa's pluralistic character. So the shortcomings that we have identified and the issues that I have mentioned as well, like those in Komoye Sondlo thing, they talk to these particular customs that we need to put through a constitutional lens, whether they entail a transformative vision of an inclusive approach for various communities, including its alignment with the modern system of governance. For example, Jezile was sent to jail for Utwala. He was charged for kidnapping, human trafficking, rape, and so forth. But the basic question which Tuzulwana raised, what is rape in a customary law context? So it comes back to us as institutions of higher learning. This is where we come from. As to what measures do we put in place to ensure that our legal education is so transformed to an extent that it caters and addresses these gaps, so that the graduates that we produce are graduates that are going to interpret these various laws within this broad framework of the Constitution. So it comes back to us. Because I must state it very clearly, colleagues, that I have an interest in customary law. I write about it, but I don't want to teach it. Let someone else teach it. And the person who's teaching it is a junior colleague. I don't have an interest. Me, I'm talking about me. That is what happens in other institutions as well. That we don't have an interest in developing customary law to an extent that these gaps, because even the judges themselves, the cases that were highlighted here, it talks to the way in which our legal education system has responded to the 1996 Constitution. The other question to my brother on the anti-corruption strategies within the institution itself. Let me express it. The institution is a legitimate institution of governance. There are no debates about it. Why? Because it has that status as well. But because of the challenges that we are faced with, not as an institution, but as communities, as government itself. So, what we need to do, the professor said that we need to build capacity. We need to empower each other so that any corrupt-related activity is washed off our communities. Let us be the examples of good leadership. We have heard of how the Koloboni chief ran away to KwaZulu-Natal because of some issues there. There are many other issues that relate to good governance. So, colleagues, anti-corruption need not be finger-pointed at government. It is us, in families. We start here. And if today, from this conference, we go around pointing fingers at how the current government has failed in dealing with load shedding. But who produced the leaders of today's? Are they not the families? So that starts there. So if we do conceptualize the essence of customary law principles and also how they respond and how they influence the general framework of the law, as is the case with the other legal systems, then we'll be moving, I think, in the right direction. Thank you.
Thank you, Prof. Professor Pogo, I am pulling rank. This was a question that was directed to all the panelists. I'm pulling rank and saying, and am saying, please answer it for all the panelists.
Thank you, Program. Thank you, Chairperson. Well, the issue in Shilubana is that the custom of the Valoi community, traditional community, if I may say so, was that only only a male could become a chief. Thus, women were excluded. But when in this particular instant, there was a vacancy, the royal family opted that they were preferring a female to take over. And that sort of did not sit well with the community. That's where the challenge arose. But coming back to your comments, remember that the traditional leaders are sort of the custodians of the culture and customs. So the court was of the view that if they decide that it is time to develop their custom, that was in line with the constitutional prescripts of gender equality, and they saw nothing wrong. whether they had to consult with the entire community and so on, I think it's a debate for the other day. But the short answer is that what they did was with what the Constitution, promotes: the gender transformation and equality, non-discrimination. Thank you.
Thank you very much, Professor. Even though it is not for me to thank this gathering, I think I just must do this part. Thank all the participants or the panelists for the manner in which they made their presentations, and also how well they responded to the questions that I posed to them. I will stop my thank you there, just in case I stray onto territory I should not stray to. May I ask Professor Njotini to come back to the podium, please?
Thank you very much, Justice Madlanga. I think at this stage we can please give our panel members a warm round of applause before we release them. Thank you very much. You can remain seated. We've got just two quick items. Is it two? I think it's one. One item that Dr. Bidi is going to render, and then we adjourn this session. But thank you so much, and thank you for making yourselves available. While Doc is making his way to the podium, the language that we share with colleagues in our task team is to refuse the temptation to generalize or make general statements on issues that are specific. We're dealing with specific matters here, and to therefore resort to general, what's the right term? Rhetoric is not going to assist us. I think it was the VC that said, while we seated here, there's someone who's selling land that belongs to the community, to people, 5,000 rand. Community members are aware of those people because they belong there, right? I'm not going to say more about it. So these are specific issues that must be dealt with. And again, in that framework document, Prof. Nhlama-Makhanya, we do indicate the specific areas that we're going to be zooming into, which are very specific, touching on very specific matters affecting society. Dr. Bidi, you can do a vote of thanks.
Thank you very much, Program Director. Should I give my panel a chance to take their seats first? Thank you very much. Oh, yes, this one. Sure, thanks. Is this not yours? Okay. Thank you very much. I'm not sure what the Dean saw in me to make me thank such important people, but it is what it is. Thank you very much. My name is Mbuyiseli. I'm with the Faculty of Law. I'm the acting Deputy Dean there. Greetings to you, VC. Greetings to you, Justice Madlanga, Justice Mbenenge, all traditional leaders who are here, and all our other honorable guests, fellow colleagues, students who are here, as well as some friends. You would agree with me, VC, when I say that indeed the debate has begun. The gathering today has resuscitated the long-standing debate on the importance of codifying and consolidating customary law.
Thank you very much, Dr. Bidi. Where to from here? That's the question. It's easy. I can dispatch with those ones before we adjourn. We will need each and every one of you to participate in a conference which we will be holding. We are in discussions as the faculty to have a conference which will absorb a wider audience talking on this very specific area of the law later this year. The dates and information will be communicated to everyone. After that conference, the team will consolidate all the contributions. Of course, there will be those that will generate research outputs, be it in articles or books, so that we also attend to the academic side of things. And the other aspect of it is to do a collection which will inform the actual codification of this important branch of the law. So all that information will be provided to all of you in due course, and those are the steps that we're going to be following. I think essentially the plan is in place. The steps that will be followed are in place, and they've been consulted with our important stakeholders. In this instance, the traditional leaders, and of course, we will extend the framework document and all the necessary steps to the wider audience. That's what's going to follow. I think, Dr. Bidi, you just made me think of something that perhaps could not come out clear as part of this event. Colleagues, Dr. Bidi has done the thank you. I'm not going to thank you again. You've been thanked. The last thing that I wanted to say was we are close to 2 hours late. But I'm sure we've dealt with everything that needed to be dealt with. We've organized lunch. It's relatively late. Okay, well, late, but I understand that there has to be a way of dealing with it. I'll start with the first. Maybe let's start with the first 3 tables to take the lunch. Actually, the first 3. I mean, the tables in the front row have organized. The lunch is organized, and then the lunch for everyone is also organized just outside the room. Colleagues can use this very same room to just deal with the lunch. I want to thank you, everyone. It's been a wonderful day. Thank you very much.